Hello, everybody. So I am in the courtroom. So we are waiting for her to be brought in and for everybody to get in the courtroom. You're very welcome. I do have sound. Let me just see if I can get anything else here while we're waiting. So Letecia has been ordered to be in court today. So thank you, Hockey Mama, for becoming a member. Thank you so much, and welcome to the memberships. Okay, they're just doing sound checks in the courtroom. There are a load of people in here, everybody. Oops, let me just turn my phone off here, you guys. Don't mind me, you guys. I'm just trying to get the best layout here. Yes, I'm going to be anxious to see. Hello, everybody coming in. I am in, so. We are waiting for it to start. I do have the courtroom up. I will start it when they do bring Letecia in. I'm just checking around over here, you guys. Just trying to get the best view for you guys here. So just give me a second. So the judge is in there. Yes, this has gone on way too long, you guys. So as soon as this starts, okay, if you guys haven't voted in the poll, vote in the poll that I've got pinned at the top. 56 likes and 120 people in here. Please smash that like button on your way in. Just pop out a chat, hit the like, come on back in. When you come back in, please make sure you have live chat selected at the top of your screen so you don't miss anything. Okay, they're just testing. They're doing sound checks right now, you guys. It's supposed to start in about 10 minutes. Yes, blue hearts, please, for Gannon. I do have a few things, Rosie, regarding Kylie, but I don't want to get into that on this stream. I will be doing an update on that at another time. This one I want to just keep focused on the Letecia Stauch and Gannon. Little boy blue deserves that, that's for sure. Thank you, you guys, for the blue hearts for Gannon. Thank you, thank you, thank you. And thank you for smashing that like button on your way in. It helps us get out there in the algorithm, let everybody know that we are live. I'm going to let you guys know, a lot of people are saying they don't get the notifications for my videos. I can hear them in the background talking. I don't think they realize that I can hear them. But there's a lot of people in here, you guys. Hello, everybody. The poll is pinned at the top. If you leave chat and come back in, it should be right at the top. When you pop out of chat, please make sure you smash that like. We got 80 likes, 136 people in here. Please smash that like button. I'm going to let you guys know, it doesn't matter whether it's my channel or any other channel. If you've got your notification bell on, you will not get your notifications if you don't have your notifications set to on in the actual YouTube app. So in the YouTube app itself, on whatever device you're using, you have to go into YouTube, the actual app, wherever you've got it saved, and you got to put the notifications on there. If you don't, you won't get any notifications for any of the channels that you've subscribed to. Thank you, Angel. Thank you, everybody. I appreciate you guys. Yes, I'm going to be streaming it. I'm just... Okay, the judge is asking us to send a chat saying that we can hear him. You're welcome. Okay, so he was just asking for us to send a thing saying that we can hear him. I think they're having a little bit of issues here with some audio. But we can see the courtroom. People are starting to stream in here. And like I said, you're not going to miss anything as soon as it starts up and they bring Letecia. As they're bringing Letecia in, I will go live with it so you guys can see it. Yes, please make sure you have live chat selected and not top chat so you don't miss anything. And thank you, everybody who put the blue hearts for Gannon. Thank you so, so much. Me too, but it's their right? Well, what upset me a lot about this case is after all the other evaluations she had done and everything, her defense team said, well, we want to get another evaluation done, not when the incident happened, but how she reacted after the incident, that we're not going to change our plea, blah, blah, blah. If you'll just allow this, judge. The judge allowed it. And when that evaluation came back, that's when they turned around and they did change their plea. So they lied to the judge. Okay, so I'm just waiting for, I think they're waiting to get the judge up on screen. We can hear him, but we can't see him. So like I said, I can hear them all talking in the background, you guys. There's nobody in the courtroom yet. Just I believe the judge is in the courtroom, but we can't see him yet. There's nobody sitting at the defense or prosecution side yet. And like I said, as people come in, they're going to get them in and get them all seated, and then they will bring Letecia in. So as soon as that starts happening, you guys, I will show you the screen and go live. Absolutely. Justice Drain for G-Man. Thank you, thank you, thank you so much for smashing that like. Yes, all victims deserve justice. Absolutely. But it's time they get going on this, you guys. Like I said, I do have some updates with the Kylie thing. I've got some updates. Chad Daybell is back in court. They have a court date. They weren't supposed to be back in court until November 6th, but for some reason, he is back in court on the 31st of August. So I will be covering that. Let me just hear what they're saying in the courtroom. Like I said, you can't see anybody in the courtroom yet, so I think they're just going to go and unlock the doors now for people to be able to come in. But as soon as things start, people start coming in, you guys, I will be going live with it. Okay, they're letting people in, so let me start sharing this with you. Okay, so everybody is coming in, you guys. No, it's just about to start, the real Angel. I think I should just put up the ones that have video on them. We may change this, you guys, but the camera is really blurry. And this one, I don't know what's going on. This is whoever Sheila is. I don't know who these people are. That's the court. I don't know who that is either. But I don't see the judge up here. They were having problems getting the judge up on video, so I believe Letecia will be over here.
Oh, thank you.
So if they do, just focus on her, you guys. There, that's a better video. She will be sitting here.
I think it stayed until it's done. So I think we can set it. Yeah.
And this is as big as I can make it, so.
I think it's cheap. I think it's all that's because we didn't tell the second about it. Yeah, we agree with you. Okay. I just don't know what he's. Okay, well, I mean, that's weird. It says, it doesn't, on the speedy trial.
This is prosecution.
Yeah. Any period of delay of billing, caused by this, and then I think. I think you read more if you put all that in.
I'm trying to listen, you guys.
Yeah, we'll go back to the day of. I think here, let me see if we can create. We're gonna make that record. Right. Yeah.
They're talking about something about the speedy trial, so.
What I think we did. Yeah. Well, that was yeah. So we get the report on August 4th. Hear this right. Yeah. Are you agreeing with it? I am.
Okay, that's my perspective.
So we're talking about 20 days.
Yeah,
Yeah.
August 4th till now. Yeah. Or until the motion. Was yesterday or the day before?
Yeah, 4 days.
Okay.
I had to read that statute like 19 times.
Yeah. It's all crazy that time.
I do reading them like when it's occurred,
Yeah.
like important, like yeah.
Talking about when the clock starts
Not really well read.
for the speedy trial. So she should be coming in shortly, you guys.
Yeah. That's, this is
I'm trying to pick up what they're saying, you guys. You can't hear Sassy because they haven't started yet. They're just whispering amongst themselves. I don't think they realize that we can hear them. No, the birds that you're hearing is from my place. My window's
So I
open.
think that
I didn't think this pre-timed.
that's
Okay.
and
That's my mic, you guys, picking up the birds from outside. Hang on, let me go and close my window so it doesn't interfere with this. And that's what you're hearing, is the birds outside my house. Hang on, you guys, I'm just gonna close this here. Okay, you shouldn't be able to hear the birds anymore. No, I have my windows open, you guys, and I have a lot of trees outside my kitchen windows, which is just the other side of my office, so that's where you could hear the birds. They're trying to get the video up and working, you guys.
How about right? Oh, you?
Yeah,
Good. That was a bus ride.
you tried to kill us.
So Gannon's family's all in the courtroom, and some of them flew in just for this status conference. Okay, so Letecia is going to be coming in now. Okay, just give it a minute, you guys. Please
All
don't.
right, so pass the time in combined courts in session. Now we'll break order presiding.
Thank you. May all be seated.
If you want the video, you gotta start video over there if you want them to see you.
Please don't give information from other places, or if you're watching it somewhere else, please don't. Don't bring that here.
I don't remember to ask. Are you good to go back?
Let me see if
All
I
right.
can get-
Court will call 20 CR 1358. People versus Letecia Stauch. Counsel entered their appearance for the record, please, starting with the prosecution.
Thank you, Your Honor. Michael Allen, J.P. Young, and Angela.
She's right here. I'm trying to make it bigger. I don't know how.
From Landon Hyatt and Alstack.
Okay. And defense?
Good morning, Your Honor. I mean, afternoon.
And
Josh
stage.
Delaney and Will Cook from the staff.
Oops.
All right. And we're here today for, as I see it, a trial setting. The report came back from CMHIP, essentially dated August 4, but I did not get it until, I think it was August 5.
Oops.
So
There we
as
go.
I see this, based on the
Whoops.
statute at this point in time, under 16.8.105.52, upon receiving the report, the court shall immediately set the case for trial.
It keeps
There
beeping
is
in and
a
out, you
motion,
guys.
for a second evaluation by the defense. We'll deal with one of the logistic issues in that
This is her here.
that's raised in that, but I think I need to go ahead and set it for trial at this point in
And
time.
you're-
Okay, he's setting a trial date.
My position that it would be more efficient to set the trial after receipt of the second evaluation. I think my reading of the statute, and I think the district attorney's reading of the statute, is that speedy trial is told from the date I make all period from the date Your Honor ordered the commitment and all reasonable period of time for that evaluation to be complete until the evaluation is to the court is told by statute. And I think once both myself and the district attorney, I believe, are in agreement that once I request the second evaluation, that again holds the speedy trial statute until that second evaluation is into the court.
That's the part that I think is a little bit less clear, largely because I would agree 100% if this were a competency.
Yes.
But because it's a sanity issue and sanity is actually determined by special interrogatories to the jury, it's a little less clear, I think. 16.
And
What bothered or what concerns me a little bit is that language that I just referenced in 16.8.105.52.
Right clicking on it does not make it bigger for me. I just right clicked and that's what I get.
what was the statute?
So
Just a second.
Sorry.
16.8.105.5, paragraph 2. Upon receiving the report of the sanity examination, the court shall immediately set the case for trial. Every person is presumed to be sane, but once any evidence of insanity is introduced, people have the burden of proving sanity beyond a reasonable doubt. And the sanity report, the sanity examination that it seems to be referring to is the initial one. Because
yeah, she's in the
Unlike-
courtroom. She's right here.
competency, which has to be determined by the court before the case can proceed forward, sanity is going to be determined by a jury during the trial. And the only, and potentially, I mean, there's a number of alternatives here. The prosecution has the sanity evaluation back. Presumably, the defense is going to challenge the finding of CMHIP that she was saying.
Who will be challenging?
Okay, so, but part of the issue would be, while you can still challenge that at the time of trial, based on the report from the prosecution, depending, and I'm not asking you to comment one way or the other, but depending on how things turn out, you could potentially choose not to present expert testimony by the defense. And that's what
Let's
causes
wait
me
and see,
to,
Jenna Lee, please.
or gives me pause.
And I guess what I was looking at, Your Honor, is 18.1.
So the defense,
405,
they've said that she's sane
6A.
again, but the
Hold
defense
on.
is going to challenge it.
1,
So let's see what the judge says.
6A. Okay.
And this deals with periods of time that are excluded any period during which the defendant is incompetent to stand trial or is unable to appear by reason of illness or disability, or is under observation or examination at the time of the issue of the defendant's mental condition, insanity, or incompetent mental condition is raised. And so I think that would include these, and because the second evaluation is granted by statute,
I agree with that.
I would think that the examination that in 16 in 18.1.405 6A, that would encompass both the CMHIP examination and the defense examination.
She's got her back to the family, it looks like.
6A. I'll get to that. Is incompetent to stand trial, so we don't have that.
So this, it sounds like this evaluation came back that she's sane. But the defense wants to challenge it. Like this is what, 4 or 5 evaluations now she's had done where it's come back that she is sane. Like this is crazy. I'm trying to find a better layout, you guys, but
What's your position on all this?
I don't want to click on something and
That the hearing is prepared to respond to.
Okay,
Good afternoon, Your Honor.
good afternoon.
We would agree with defense counsel's analysis that the speedy trial statute, 6A particularly, would allow a speedy trial to be told essentially at the moment they file their motion,
I agree with that.
which is a couple of days ago. And so that's our position, that it's told up until we get a report from their expert.
Let me pause this for a moment. We'll go to some logistics and that may solve some issues anyway. As you know, the defense does not have much obligation to disclose a lot of what they're doing. But because you've requested a second evaluation, first of all, it's got to be state rate, state pay. I have to know who that is so I can approve so I can issue an order.
And Your Honor, I can tell, Your Honor, I've had discussions with the head of alternative defense counsel. I will, probably not like me saying this, but my reading of the statute and alternative defense counsel's reading of the statute is the sanity is different than competency. While competency specifically states that the state will pay for the second competency evaluation by their choice. And this is coming from discussions with the state office that it is, we have a right to it. It's different. We do not have a right to have judicial pay for it. So what I can tell the court is we have retained a psychiatrist. The psychiatrist is going to be coming from out of state, and we just need to figure out the logistics of it.
Okay, so I do not need to, I will not be receiving an order for request for payment for that person.
You will not.
Okay, the next issue is based on the motion. There was a request for an EEG monitor for 72 hours.
72 hours, yes, sir.
And I understand that the jail cannot accommodate that, and the request is that the evaluation be done at the state hospital.
That is my request.
I don't think I have the jurisdiction or authority to order that. I can order her to the state hospital. I agree with that. But I don't think that I have the authority to order them, to order the conditions under which she's going to be housed or evaluated by a second evaluation.
And I would have the court look at 16.8.109, 1A. And my reading of this is that the court,
Hold on, that's got to be a,
108.
16.8.109,
thank you.
1A.
Wrong statute. All right. And I reviewed this, but go ahead.
And my reading of this is the court shall order the location of the examination, which may include the Colorado Mental Institute at Pueblo.
I agree with that. But it also, if you look back up here under 16.8.108, 1A, second sentence. Second sentence, an interview conducted pursuant to a court order under this section must be video and audio recorded and preserved. It does not provide me with the authority to order them really to do anything else.
And
So let me make sure I understand the request. The request would be that she go to CMHIP.
Yes.
To be evaluated by somebody who is not CMHIP staff.
Right.
And part of whatever this person wants to have done is that she wear apparently a continuous EEG monitor of some sort for 72 hours.
Yes, sir.
That's the part I'm not sure that I can order.
And just for clarification, it would be our position that we would bring in, more than likely what we'd be bringing is a separate neurologist who will have his own EEG and hook it up to her there at the state hospital. And so we're not asking the state hospital to perform any test. We will bring in our own equipment to the state hospital and have that done. We're just saying that I think the place that is will be best to conduct the examination so that we can have a full and fair right to this examination would be at the state hospital.
But if the concern that I have is the length. Obviously, the interview itself has to be audio and video recorded.
Yes, sir.
And that's usually several hours. But presumably, she's not going to be strapped to a bed for 72 hours. She's going to be able to move around and those sorts of things. And I don't know how portable this device is. I mean, the ones that I've seen, they're older and they still have the wires. I don't even know if there's wireless anymore or available now. But what I'm concerned about is I don't think I have the authority to tell the state hospital that if, for instance, and I'm making some of this up, she's supposed to be wearing a cap and the cap comes loose. I don't think I have the authority to tell the state hospital to do anything with respect to that cap, and the neurologist isn't going to be there for 72 hours straight. I agree. I have the authority to order her down there. I can have the evaluation down there. It's the specific request that you're asking for that I don't know that I have the authority to order. If you want to talk with CMHIP and they're amenable to it, it doesn't matter to me.
Okay.
But I don't think I can say, CMHIP, if you don't want to do this, you have to. I don't think I have the authority to tell them that.
I guess.
You can think about that, Mr. Allen?
Judge, I was just gonna mention something along the same lines that you just suggested, that we probably can't make a decision on that part of it unless we hear from somebody from the state hospital. There are probably legitimate security concerns about connecting a person that's being secured.
I think they're worried about the wires on it. She could strangle herself or whatever with the wires. That's why they're worried about it.
Specifically as it relates to this defendant and what's.
Like you're giving her an apparatus to do something with that apparatus other than what it was intended to do. And the judge cannot order the state to do anything. Once she's at the state,
Yeah.
once she's at the state hospital, it's their rules.
The EEG monitoring without some sort of input from CMHIP. It's your call how we can do it. We can do it by hearing. You can talk with them first. Because I agree. There's not any question in my mind that I have the authority to order a second evaluation, even by a non-CMHIP person at CMHIP. I have no question about that. It's this device that I'm concerned about. Because obviously you have and I'm not asking you to disclose it, but you have a reason for it. And I'm not sure that I have the authority to order that under the circumstances. I probably could order it to take place while he's there. But you're asking for 72 hours instead of however long the interview is going to be.
Yeah, I guess what I would propose then, if we want to set a hearing in 3 weeks. That way it'll give me time to contact Dr. Gray at the state hospital to kind of get their, you know,
EEG
opinion
is
on
to
it.
monitor your heart rate and
You know, and
everything.
then I think it may raise a lot of interesting issues.
You
as
wear
far as,
it
like, due
for
process rights
72
to,
hours. It's,
you know,
it's
evidence
across your
and so
chest.
forth versus, you know, the fact that it should not prejudice Ms. Stauch's preparation for trial, but the fact
EEG
that
is
she
not,
held
I don't think, for
without
the
bond.
brain.
And so I think that we're going to have maybe some
Because I've had to wear one of those
conflict between
devices
some
for my heart.
individual interests and so forth. So if we could have 3 weeks, that will give me a week to kind of get the state hospital's
It's an
input,
EEG.
and then that will also
Somebody
give me
look it up on
ability
Google.
drafting it further in depth, brief time to do that.
The other issue that we're gonna have to look at is, obviously the same one that we faced in getting her down there initially, which is, their wait time on doing it. And I don't know.
So EEG is for the
Uh,
brain. Okay, EKG. Okay.
And I can
ECG
contact
is
them
heart
as
rate.
well, because I'm not sure how much the wait time is on doctors.
Okay, so they want to test her brain waves.
Well, that's
Well,
what I
If
wonder.
the wait time may be a little bit less, because we'll be the one performing evaluations, but I can contact Dr. Gray and talk to them about that.
Well, the only
Yeah, and they
issue
want
though
this-
is that she's gonna have to be down there for at least 72 hours, right?
Yes.
I mean, I wouldn't think that the staffing of the doctor would be the issue because.
yeah, somebody would have to watch her every minute that she has that on.
There's still going to be a staffing issue. And if it's 72 hours, there's going to be a bed issue. And so we probably need to have that fleshed out as well.
So they want to check her brain waves or something. I don't know.
1:30. Yeah, we can judicial.
September 15,
Okay.
1:30. And if we're going to have testimony from somebody at CMHIP, you can tell them they can appear virtually.
Okay. I think that makes sense. Thank you.
Judge, you said September 15th.
Let's not mention other cases and everything in this, please. This is about Gannon and Gannon
Does that work?
only.
That works.
Okay. So hopefully by then we'll have a better idea and I will take a closer look at, I wish the statute was a little bit more clearly written, but
I think everybody concurs with you.
so clearly though, there is some.
I don't know who
issue
this
about that
is.
right now. So we will figure out where we are. It sounds as though that the
But
people
somebody put
read
their
the
camera on.
statute the same way that Mr. Tellini does, which is that it is told until probably the distribution of the second evaluation.
I think the confusion is this new statute that allows the court the ability
Yep.
to order a second evaluation.
Right.
Came into effect in 2016. So everything before that
Mhm.
is under, normally the defense would have to go obtain their own and
Right.
do their own evaluation. So I think that's why the confusion is. That's why we turn to the speedy trial statute, which directly addresses any time that was used for this evaluation.
Well, when I looked at the newer statute, I didn't find.
The
any
judge
case
doesn't
law
have
that
any
addressed the
choice.
issue.
They have
Okay.
the right to challenge this last evaluation. And
Well,
apparently
that's
it came
why
back
I
that she
didn't
was
find
sane.
anything.
So now they're
what
challenging it. They
concerned
want
me
their own
was,
person to do it now at the state hospital, and they want the state to pay for it.
16.105.2, but I would agree that 16.14056A talks about all of those.
They're just
reports
talking
as
about
well. So
statutes
it's,
right now, but no, the judge is concerned
yes,
that
we will
she's left alone with this machine, that
see
she
where
could
we
use that
are
to
with
do
respect
something
to CMHIP
with it other than what it's intended
in
for.
3 weeks.
And he doesn't want to be held responsible
It
for
would
that.
be helpful, to the extent possible, to get any idea from CMHIP how long a wait we would be talking about. Because I just.
They're
part of the
testing now
statute
for
is
how she's
that
dealt with
since
things
this part
after
is
the fact.
new, I know that they categorize competency evaluations and sanity evaluations differently.
I get it, Latoya, but
this
I want to
isn't
stay
either
on
one of
case
those.
here.
So it would be helpful to have some input from them about how long do they think this is going to take.
Yes, sir.
Okay, all right. All right,
I apologize.
yes, no, go ahead.
I do believe that the statute that we've been discussing says that you need to advise the defendant the second evaluation, that the video recording be turned over to us.
Because this is going to be the second evaluation on her sanity after the fact,
I
not
agree with
while she
that.
committed the
It
crime.
is, let's see, 16.
It's 1A, 16A, 1A, 108, 1A. The court shall advise the defendant that any examination is
Look,
This will be the last one.
and it's the same advisement that I gave before, except it is just now with respect to her being seen by her own.
He can't deny it. They have a legal right to it. Because when she entered her insanity plea, not guilty by reason of insanity, the judge automatically has to send her to it for an evaluation. And this is on her sanity after
Mr.
the
Tony, I
fact.
just happen to think,
And
I
then
need to have some idea also
The
as to
defense
how long
has a right to
do you think
challenge
it's gonna
that.
take your
because the state
expert
did it.
to get a report once the examination is done?
I just spoke to her 2 nights ago. She is hopeful that after the examination is done, within 30 days,
Okay,
after that, she would have the report done. She's
So
in the
30
process
days
of
once the
reviewing-
report's
She's
done.
been reviewing material for a while.
okay,
So we're doing everything we can to hurry along the process.
okay. The only reason I bring it up is because of the language that's in the statute about,
The state's fitting the
actually
bill,
it says that the
Yvette.
examiner chosen by the defendant should be given a reasonable opportunity to conduct the examination. So I just need to have some sort of idea. Ms. Stauch, you've heard your attorneys and I talk about this a lot. It sounds like you've already had one sanity evaluation at CMHIP. Your attorneys intend to challenge that evaluation, which means that they intend to challenge the finding of that examiner. That means that they're going to obtain a qualified individual to conduct a second examination at their choice or at their request. During that examination, again, that examination will be audio and video recorded unless the provider makes very specific findings as to why that it can't. A copy of the recording must be provided to the prosecution along with a copy of the examination report. So once that examination is done, the video and audio recording will be provided to the prosecution. And any report that is generated by the person that's going to be examining you will also be provided to the prosecution. In addition, obviously, nothing that you say to the examiner is protected by an attorney-client privilege, and anything that you say to them can be used against you at some point later in the proceedings. It's the exact same process that we went through before. Do you understand?
Mhm.
Okay. Sure. As a result, any statements that you choose to provide in cooperation with the evaluation may be used by the prosecution as either impeachment or rebuttal evidence if you testify. Any statement you choose to provide in cooperation with the evaluation may be used in any sentencing hearing in the event that you're found guilty. Is there any further
Once this is done, you guys, it will be private for about 30 minutes while I upload all the
No further
descriptions and
advisement. I just,
everything.
couldn't tell whether the defendant was answering.
So if you are just joining and you want to start at the beginning,
Okay.
it will be
I thought she
unavailable
said
for about
yes.
30 minutes before it's
Let
back
me ask the
up
court
for
because
everybody
that's
to
the one that's
see.
going to matter. Okay. And Becky is nodding her head. It was not at a high volume, but I thought she said yes. So is there anything else that we need to address at this point in time?
Not from the people. That's
Mr. Delaney? No, sir. Mr. Cook?
No, Your Honor. Thank
Okay.
you.
All right. Court will be in recess then. Thank you.
All rise.
So that's it, you guys. Okay, so that's it. Oops. Let me just close these out, you guys, these other tabs, so I don't get bogged down here. Okay, so she's back in court September 15th at 3:30. I do not think they're going to be doing much there either. But they will be back in court, I guess, just to update whatever. So between now and September 15th, she has to have this evaluation done. I'm going to go over what was said and done for those who didn't really understand it or have other questions. I will take them when I'm done explaining this. They have to have it done by that day, and then they get 30 days to get the report done up. So we probably won't hear the outcome of that for another 30 days after September 15th. Now, what's being done is the judge wanted a trial date. He wanted to set a trial date. The defense came out and said that they are going to challenge this evaluation that just said that she was sane again. Now, what happened when she changed her plea from not guilty to not guilty by reason of insanity? The judge has to send her for an evaluation by law, has to, at the state's expense. That's the evaluation she just had now. This evaluation was done for the purpose of, was she sane after the fact, after she did what she did to Gannon, when she disposed of his body, stuff like that. That's what they are questioning now is, was she sane then? That's all this one is dealing with, is from once it was done and then she took the body and everything else and went and hid it in Florida and all that crap. They're saying then that she was insane. So when she changed her plea from not guilty to not guilty by reason of insanity, the court has to get another evaluation done. That evaluation came back that she was sane. Now the defense has a right to challenge it, which they are doing. So which means she's being sent for another evaluation, which she just went through, but the defense does not want any staff from CMHIP, which is the mental state hospital, to evaluate her this time. They want to bring in their own evaluator. They also want her to wear an EEG monitor for 72 hours. The judge has no authority to order that. Okay, the judge cannot order the state hospital to do certain things, etc. He can order them to do an evaluation or allow another evaluation to be done by whoever the defense decides to bring in. But the state hospital has security things in place because from what I know of EKGs and ECGs, there's wires and everything all attached. This gives her a device that she could use to do something with other than what the purpose of that device is for. So could she zap somebody? I don't know. I don't know what she thinks she could do with this EEG monitoring equipment, but I know there's wires on it. She could possibly strangle herself. She could do all kinds of things with it. So what the judge is saying is they would have to watch her for the full 72 hours, never take their eyes off her as she's wearing this device, which he says he cannot order anyway. That's going to be up to the state hospital. And what he said with the shortages of staff at the state hospital, he doesn't think that that is going to be feasible. There's no way short of strapping her down for 72 hours that they can have this device on her for 72 hours without being constantly watched or strapped down, whatever. So now they argued clauses, they argued different citations in there to get what they wanted. The judge stayed firm, which I believe he should have. He cannot order the state hospital to do anything other than the evaluation or allow somebody to come in to do that evaluation. Once she's in that state hospital, they are responsible for her safety and security. So they're not going to allow, I don't think they're going to allow this EEG to be worn for 72 hours. I don't see it happening. So yeah, I don't know what she thinks she can use with this monitoring device, whether it's good. She thinks she can use it to strangle herself or do something. I don't know. I don't have her mindset. So whatever it is, the judge is trying to put a kibosh on that really quick, and he is not going to order that at all. So, no, Angel, I'm not saying she has to be in bed for an EEG. What I am saying, I'm going to repeat it again. For her safety, they would have to strap her down so she could not reach this equipment that's going to be strapped to her for 72 hours. That's the only way that they could do it safely. They don't have the staff to be able to sit there beside her and watch her for 72 hours straight, day in and day out, hour for hour. They don't have the staff to do that. So the only way that it could be done safely, that she could not use this equipment for some other means, is to strap her down. I'm not saying you have to be strapped down for an EEG. I'm saying that's the only way that they would be able to do it safely without her being able to get to this device, is to strap her down. Didn't say she had to be strapped down for it. Now, if it's that important, absolutely strap her down then. Right. She could mess with the wire. She could do anything with it. So short of having somebody watch her 24/7 for 72 hours, which they do not have the staff to do, they would have to strap her down to a bed when nobody could be with her to watch her. Okay. Now, does that go against her human rights? Probably. And then they're going to cry foul about that. So it's like, I don't know what she would try and do with it, but short of maybe giving a false reading or something like that, I don't know. So Letecia back in court, 1:30. So that's 3:30 p.m. Eastern. Now, is she going to be in court? Probably not. They're just going to be doing like a status conference to make sure that this evaluation is done. And then they got 30 days once this evaluation is done to get the report made up. The defense said that it would take this psychiatrist 30 days to write up the report and get it to everybody. Well, I think that she's going to try and do something. I mean, that's not up for us to decide or debate, you guys. Between the jail and the hospital, they have their own set of rules of what can be done and what can't be done. That's going to be up to them. If the state hospital says, look, we do not have the staff to watch her constantly every minute of that 72-hour period, then it ain't going to be done. The only other way I could see is the only time that they would have to strap her down so she can't mess with the machine. And when she is not strapped down, then somebody would have to be constantly have eyes on her every second that she is not strapped down. That's the only way I can see them getting this done. Okay, who's okay, stop putting this crap in here. She's not pregnant. Can the mods please take care of this crap that's coming in? Oh, she's pregnant and everything else. Stop with this. Trying to find it here. I got to stop what I'm doing now to go and whoever's putting that in chat that, oh, she's pregnant, whatever, stop it. Stop it. Why do we have to have one in every group that comes in and starts this crap? Yeah, that's exactly. Thank you, sweet crazy. That's how rumors start. Okay. So Roxy, you know what? You're going in a timeout. Stop it. Oh my God. Oh, she was talking about Letecia that is pregnant. She was just good. No, whoever starts crap like this, get them out of here. Like, this is how rumors start. My channel is fact-based, verified information. So for somebody to come in, the next thing you know, oh, you know what? We know Willow doesn't allow anything that's not verified. But so I heard in her chat that something about Letecia's pregnant. Like, stop it. I don't want it in here, please. Yeah, I get you, Bebop. You don't gotta, like, I get that you guys are now responding to that. I'm not talking about you guys. I'm talking about the person who put it there. Is she pregnant or she's pregnant? Whatever was said for you guys to react the way that you are. My chat is just flying by, you guys. I'm trying to scan my chat for questions and stuff, and I just happened to see that. So please, mods, stay on that. People putting stupid stuff like that in there, just time them out. Remove the comment and time them out. I'm not talking about the people who started asking about it. It's not your fault that somebody put that in there. It's not your guys' fault. So whoever is putting stuff like that in the chat to get my subscribers going and questioning it, just get rid of them. Harley is on the witness list for the prosecution. Oh, she's going to stand trial. She's not going to be found incompetent. She's going to, yeah, she's doing this to drag this out as long as she can. She's doing as much damage as she can. It's sad. You're welcome, Tia. Yeah, so whoever started putting that in here to get you guys going, just get rid of them. Sorry, you guys. My allergies are through the roof. My throat is so dry with all this pollen and stuff. I've been outside most of the early afternoon because we did the gender reveal for my daughter today, and I cut it short so I could jump on and bring you guys this. Oh, so if you see me muting, that is why. My sinuses are blocked. My throat is itchy. So yes, so we did the gender reveal. I am having a grandson. So it doesn't matter if my daughter's in here now. I doubt she is. She's gone out now to celebrate a little bit more with her friends. But I cut the gender reveal short and got everybody out of here so I could bring this to you guys. So it's a boy, Rosie. It is a boy. Yes, Kelly B, I agree. She is trying to delay. Laurel's heart. I love it. Strap her down with the diaper on. I don't know. I think they have FaceTime visits or some stupid thing that they can do. Yeah, Harley's going to be put in a really bad position, you guys. Then there's, I don't know what is going to happen there. When you got one saying she is and one saying she's not, there'd have to probably be another one. I don't know. I don't know what they would do in that case. Exactly, Yvette. Exactly. Yeah, she doesn't want the prison. She wants to stay in the comfy jail. She's in jail right now. She's not in prison. Hello, Jilly Bean. Thank you. Thank you, everybody. Thank you. Thank you. It's going to be my second grandson. I've got 3 granddaughters, and this will be my second grandson. Thank you, everybody. Thank you. Thank you. So yeah, so this is what's happening, you guys. They're challenging this, so I do believe that it came back that she was sane. I will watch for the documents to be filed, whatever it is filed on there. and they're going to have to file paperwork to say what they disagree with and what. I don't know if it's going to be sealed or not, but I will be watching her file. And if anything does come out that I can share with you what was in this evaluation or anything like that, I will. Yeah, she, thank you. She knows exactly what's going to happen to her. Now, wait a minute. I got something else to tell you about Letecia. Hang on a sec. I seen this, and apparently it is verified by somebody who was in jail with Letecia. And this is what she said. Hang on a sec, you guys. Let me find it. Let me just find it here. Okay, so this lady says, I just got out of jail a few days ago, and Letecia was in my unit. She was walking around like she did nothing wrong, completely competent. She has friends. This is what she states. She has friends, completely competent, started a Bible study. She was telling people she's cartel and she's the shit. The rest of us were like, what? Rumor was if anyone touched her, we'd automatically get 5 years. I sat and dwelled with that one for a bit. Probably worth it, but I only had 30 days or so to go. Most of the unit does not like her. We were in Alpha 1, so our rec out times were 8 a.m. to 8 to 2 a.m. I don't get this. 8 to 2, and then lockdown, then 3 to 9 p.m. the next day. So 8 in the morning to 2 in the afternoon one day, and then the next day they'd be out from 3 in the afternoon till 9. And then it would switch. They keep going back. Upper tier locks down when the bottom tier is out, and vice versa. So that's from somebody who was on the same unit as Letecia. That she's going around telling people that she was, she's cartel. I guess they were also told by guards that, or she said, if anybody was to touch her, it's an extra 5 years. And but she said by the way that she acted inside, she's completely competent. She started a Bible study group and everything. Yeah, when she gets, well, Angel, I don't know about that because she'll be put in a section of the prison with like-minded people and people who have done the same crimes as she has. Yeah, she's a child killer, but she will be put with other child killers. She will be segregated from general pop, for sure. Thank you, Dreamer. Thank you so much. Yeah, she does. She thinks she's untouchable. So we'll have to see, you guys, what this next evaluation brings. Like I said, the defense is by law. The judge is following this, so there is no reason for appeal. So is it frustrating for us? Absolutely. But he's doing this because he doesn't want to give her any reason for appeal. So, and by law, they are entitled to challenge any state-run and state-ordered psychiatric evaluation. They can challenge that and have their own done. They do want it done at the state hospital. I guess Letecia is loving the state hospital, the nice food, comfy bed. She's probably got her own room. She can use the phone and everything there. Like, she's got a lot of privileges at the state hospital that she doesn't have in jail. So there's that. That's the only reason I think she wants this second evaluation, because she likes the coziness and the comforts that she gets at the state hospital. So again, I'm going to let you guys know, those who are just joining, once I end this live, it will not be available for about 30 minutes. It goes private, so I can get all the description done, get in the dates that are coming up, get in the tags and thumbnails and all that stuff. And so it can upload. So that's where we're at, you guys. Okay. So with that being said, I'm going to let you guys get back to the rest of your day. I do have some updates coming on the other cases. I still have a read to do on Zach Burns that was requested. I was supposed to do that, but then Jalissa, her read was requested by many more, and I seen that it was on the list before I actually got the request to do the Zach Barnes read. So I will be doing the Zach Barnes read. Another guy, just a young like Dylan, good looking guy, and you know, gone, face of the earth, gone. Yeah, she's claiming that she's cartel because she wants everybody scared. If you're part of the cartel, you don't tell people. That's for sure. So, okay, you guys. So until the next time, you guys, please take care of yourselves. Please stay safe. Watch my community tab for any updates. They will be posted there. Like I said, if you're not getting your notifications, you got to put your notifications on in the YouTube app itself. Okay? So until the next time, you guys, please take care of yourselves. Please stay safe.